Hello friends, welcome to CEC Gurukul Live Lectures. Dear friends, today we are going to talk in our series on copyrights. Our topic of discussion is Intermediaries Liability for Online Copyright Infringement. And for the discussion on the topic, we have with us in our studios Dr. Ashwini Sewal. Dr. Ashwini Sewal is Assistant Professor in Faculty of Law, University of Delhi. Dr. Sewal is a prolific professor and we are always delighted to have him in the studio because through him we get in-depth knowledge on various topics and issues. Friends, if you have any questions in mind while listening to us, feel free to talk to us through our toll-free number. Our toll-free number is 1-800-110-430. I repeat, our number is 1-800-110-430. Now, I would like to welcome our guest, Dr. Ashwini Sewal, once again, and would request him to give us in-depth knowledge on today's topic. Hello, sir. Welcome to the lecture.
Thank you, Gitika. Good morning, viewers. We have been discussing a lot about copyright issues in past. There have been several lectures on which we have delved upon the issues of copyright. We have seen what are the different rights under the copyright law. We have also discussed about the ownership issue in the last lecture. Now, viewers, I would go one level advanced and I would see and discuss intermediaries liability for online copyright infringement. We all know that copyright infringement does not only take place in a physical format. There is a possibility of copyright infringement even online, because nowadays majority of the research, majority of the work is being done through internet, and we all refer to internet resources. We all, take material from different websites, we take material from internet. Out of that material, few materials are open access and there does not lie any copyright on those materials. But in majority of the cases, the materials are owned by someone and we are not supposed to copy those materials even if they are available online, even if they are accessible through our computers. That must not be copied by us in any case whatsoever. This is one component on which I would focus today in my today's discussion. Another component of my today's discussion is the liability of the intermediary in case of copyright infringement taking place in an online medium. Well, my dear friends, before taking you to intermediaries liability directly, I would first emphasize upon the different vistas of online copyright infringement as to how copyright can get infringed in an online medium. Let me give you some examples which are real-time examples. I just said that several works are available online. Sometimes we copy those works without the authorization of the owner of the copyright on those works. That actually tantamounts to infringement of the copyright, and we can be held squarely liable for the copyright infringement. So there we know we need to know as to what would amount to copyright infringement and what would not amount to copyright infringement. So for this, copyright infringement as such, we need to refer to section 51 of the Copyright Act 1957, which categorically says that any work copied or taken away without the prior authorization of the owner of the copyright shall amount to copyright infringement. My dear friends, if you look carefully the language of section 51 of the Copyright Act, it nowhere says or it nowhere make a specific medium or a platform on which a copyright infringement can take place. It simply says that copyright infringement can take place in any medium whatsoever, be it a physical medium or a virtual medium, if a person unauthorizedly copies any of the works of the owners of the copyright. Well, there are real-time examples which I was talking about. For example, if you take a picture from the internet or from any website, and if you are using that picture in your work, you never know that you may be held responsible for the copyright infringement because somebody may own a copyright protection on that picture. So is the case of literary work. If you are referring to a research paper, if you are referring to any of the studies available online of any author or of any jurist, or for that matter of any person who is a prolific author in that area or in that field, you see, you may be held liable for the copyright infringement of that literary work if you have taken that literary work, copied that literary work without the prior authorization and without acknowledging the source as such. Similarly, you see, taking away any visual work, audio work, or for that matter animated work, right? These are several works which we see prevailing on the online medium nowadays. Whenever we watch a copy, movie or a cine film online, we happen to create a transient file or a accidental storage of a transient file in the form of a temporary file gets stored. Even if we have not stored the entire movie on our system, still some of the portions will get, or you can say some temporary or transient storage of that particular visual file or that particular cine film will get stored in your system. So that storing, whether that storing will be infringement of the copyright or not, that is the question that we need to ponder over, that is the question that we need to understand. So during today's discussion, we will see these different questions in light of one specific issue, that is intermediaries liability. Well, my dear friend, suppose we are taking a stuff from online medium, we can be held squarely liable for doing that wrong. If we are doing a copyright infringement in an online medium, we can be held responsible. But what about the responsibility of the intermediary? What about the liability of the intermediary who has just facilitated us in the dissemination of the content, who has made that content accessible to us, who has just made that content available to us? They had a limited role to play. They had not actually connived with us in infringing somebody's copyright, but they have just facilitated us in having an access to the different sort of works available online. So they are just the facilitators. You can call intermediaries are the people who allow the third party data or information to reach to us through several means and mediums. In the internet medium, you see, their role is confined to making the works available to us. Some works are copyrighted works, some are not. The works which are copyrighted works, the possibility of the infringement of those works lies in every case, because any user or a subscriber may access and may get to infringe the copyright online. So there are two issues now. What would be the responsibility of the person, the user or the subscriber who just downloads who just accesses and stores, reproduces the copy of owner's copyrighted material? This is one aspect. Another aspect is the liability of the intermediary who has just facilitated that work to reach to us, who has just facilitated that work to be made available to us, to be accessible to us. What about his liability? These are the two questions that I am going to squarely cover in my today's discussion, and for that, this would be our scheme for today's discussion. We will see, first of all, the definition of intermediary as provided under Information Technology Act 2000. Well, my dear friends, to get the definition of intermediary, we need to refer to the Information Technology Act, because the definition of intermediary is not provided under the intellectual property regimen. Instead, it is provided under Information Technology Act. Then the next thing that we are going to do in this discourse, We will also see what constitutes online infringement, what constitutes actually online copyright infringement, I mean, because as I just gave you an examples that it can happen anytime, whenever we store, whenever we save, whenever we access any copyrighted material lying internet freely may land you into trouble, because you may be held liable for the copyright infringement if that stuff is copyrighted stuff. Then third thing that we are going to tackle and address to in this discussion is how far intermediary can be made liable. The user, the subscriber, the person who is downloading, restoring, or you can say reproducing or saving the copy of the copyrighted work, he has to be made liable, and it is his primary liability that has to be fastened on him for the copyright infringement. But what about the liability of the intermediary? Will he be made liable for primary infringement or for the secondary infringement? We will discuss that in today's discussion. Then we need to see the exemptions under the IT Act 2000. Exemptions, I mean to say, when I refer to exemptions, I mean to say the exemptions provided to the intermediary. And these exemptions, my dear friends, are well within international norms, or they comply with the international norms. We have many international covenants and treaties in relation to immunities to be provided to the intermediaries, and under those immunities we have the rule of safe harbor. In our exemptions under the IT Act 2000, we have just complied with the safe harbor provisions prevailing across the world. Then we will also see what does copyright law say as far as this aspect is concerned. Well, my dear friends, let's move ahead and see the definition of intermediary first of all. Friends, IT Act in its definitional clause, section 2, specifically under clause W of section 2, defines IT Act as follows, defines intermediary as follows under the IT Act. It reads that intermediary with respect to any particular electronic records means any person who on behalf of another person receives, stores or transmits that record or provides any service with respect to that record. It also includes telecom service providers, network service providers, internet service providers, web hosting service providers. Even search engines are included in the definition of intermediary. Online payment sites are also intermediaries. Online auction sites are also termed as intermediaries. Online marketplaces and cyber cafes, even cyber cafes fall into the category of the definition of intermediary. Friends, if we look at this definition and if we threadbarely analyze and read this definition, we see that many of the players who play a key role in the smooth functioning of the internet medium are falling into the definition of intermediary, and if they are hand in glove with the user or the subscriber, or if they are hand in glove with the person who is accused of copyright infringement, then even these people who are enumerated in this list or in the definition of intermediary can be held responsible for the copyright infringement with the equal enormity or with the equal punishment. Well, my dear friends, if you look at this definition, it primarily reads that intermediary with respect to any particular electronic record means any person who on behalf of another person receives, stores. Let me give you an example as to how this medium functions. On the one hand, there is a server from which you see the receiver receives the or accesses the internet medium. In between the server and the receiver, there lies one more entity, and that entity is called the intermediary. These intermediaries actually are acting like facilitators who makes the informations provided by the persons on the server to the persons on the receiving end, or at the point of the receiving end. They receive the information, they access the information, they get hold of the information through these intermediaries. If you look carefully, their role as such is to facilitate the smooth dispersion and dissemination of the information uploaded through the servers by a few persons, or stored through the servers, or transmitted through the servers to the people who are the users and subscribers of those informations. So they just act like facilitators. But you see, their role does not remain confined exclusively and absolutely like facilitators, because they also come to know as to what is being uploaded. If they pay heed and if they try to get hold of the information, even they can come to know as to what is being uploaded and stored and transmitted to these people on the other side of the spectrum. So intermediaries' role is kind of, flexible in a way, and it's twofold actually. One is that they facilitate the users and the subscribers in accessing the information stored and transmitted through this medium, as well as to look at the information if they need to do so, or if they have been notified to do so, or if they want to do so. But generally speaking, intermediaries, my dear friends, are never responsible or are never supposed to see what is being uploaded, stored and transmitted. Their role remains confined as facilitators, though they are such medium that they can see the information, but still they avoid to see the information, and it is humanly impossible for them to pre-screen everything that is being uploaded or stored and transmitted through them. So they don't actually practically see what is being stored, transmitted and made available to the users on the other side of the spectrum, or to persons on the other side of the spectrum. They don't ever see the data, the information made available through them. But mind it that they can do so because they have that capacity, but pre-screening of every bit of information is impossible at their end. So they just remain confined into their role of facilitating. Facilitating means that by making it available to the public or communicating it to the public, that is what they do practically. Well, my dear friends, if you look at this definition, it reads further that even telecom service providers are falling into the definition of intermediaries. Network service providers are falling into the definition of intermediaries. ISPs, mainly internet service providers, are falling into the category of intermediaries. Web hosting service providers, search engines and so on and so forth as written in this definition. My dear friends, in usual cases and generally under the Information Technology Act, we have seen number of cases coming of online copyright infringement against ISPs, against internet service providers, and there are a hell lot of cases available on this aspect of India and of other jurisdictions. But when you go to see and when you want to see the cases against telecom service providers for copyright infringement, or for cases against web hosting service providers for copyright infringement, or for online payment sites, you will rarely see the cases because there are very minimal number of cases against these parties, but they are still called intermediaries, and they are intermediaries. They can also be held liable for online copyright infringement because they fall very well within the definition of intermediary. During our discussions, my dear friends, we will restrict our discussion on ISP's liability, or you can say on internet service providers liability, which is an intermediary, or you can say which fall into the definition of intermediary only. Cyber cafes are also intermediaries, my dear friends. Kindly keep it in mind that even cyber cafes can be held responsible for online copyright infringement because they are intermediaries. Now let's jump ahead and see what does online infringement mean. This is the second component of this lecture, where we need to see what does online infringement mean, how does it happen, who can be held liable, who all can be held liable, who is exempted, who is not. Well, my dear friends, as far as online infringement is concerned, unauthorized reproduction of copyrightable material is called online infringement, or can be called online infringement if it gets proved in the court of law. Or unauthorized issuance of the work is also called online infringement. Well, coming to the first instance of online infringement, unauthorized reproduction of copyrighted material. The example of same can be when you store an electronic copy of somebody's literary work in your system. My dear friends, that is called unauthorized reproduction of copyrighted material. You don't come to know whether it is a copyrighted material or not, since not many number of authors follow the pattern of writing it explicitly that they own a copyright on that material. And since copyright is an automatic protection regime, there is no formality to be done for fetching a copyright protection. So it comes automatically the moment the person creates a work. Suppose I have written something, a poem, and have uploaded it on an internet, on my social media account, say Facebook or LinkedIn, or on Twitter for that matter. That poem also is a copyrighted material, and a copyright lies with me, no matter that I have not taken a protection on that by formally filing a copyright application in the Copyright Office. Still I have a protection provided or rendered through the copyright law to me. If anyone reproduces that work, say he or she stores it into his or her system, then that would amount to reproduction, and that is an unauthorized reproduction. The person concerned can be held liable for the online infringement of my copyright. Similarly, if someone issues my work without my prior authorization to other people, to other platforms, or through other platforms, even that person can be held liable for online infringement of my copyright, because according to the copyright law of 1957, I have bundle of rights available at my end or at my disposal. For example, I have a right to reproduce my work. I have a right to issue copies of my work to the public not being already in circulation. I have also a right to communicate my work to the public. These are my prerogatives and privileges. If anyone is found doing these things without my authorization, then that person can be held liable for online copyright infringement. Mind it, we are talking about the online copyright infringement. Well, my dear friends, let us now talk here at this juncture only about the responsibility of the person who does these following acts written on your screen unauthorizedly. As per section 51 of the Copyright Act 1957, that person shall be held responsible for the copyright infringement, except his or her case falls well within the exceptions provided under section 52. Otherwise, he or she shall be made squarely liable for the copyright infringement in an online medium. But we are also concerned in today's discussion about the intermediaries liability for this kind of infringement that is taking place online. My dear friends, an intermediary shall also be made liable if the intermediary is found hand in gloves with the user or the subscriber in unauthorizedly doing any of the following things written on your screen. Or if it gets proved that the intermediary did not apply the due diligence after the actual knowledge that the work is a copyrighted material and is being reproduced, is unauthorizedly issued and unauthorizedly communicated and disseminated, etc. In that case, or in these cases, when the intermediary does not pay a due diligence, when the intermediary, notwithstanding the actual knowledge, still lets the work spread through this medium or their platform, then they can be held liable. We will further develop on the aspect of intermediaries liability in the following slides or in the ensuing slides. Well, my dear friends, as far as liability of intermediary is concerned for online copyright infringement, let me take you to one section, that is section 79 of the IT Act 2008 and section 81 of the IT Act 2008. These are the two sections which are to be read along with section 51 of the Copyright Act 1957. Well, my dear friends, it's a trilogy of three sections which are all the more important or crucial to understand this topic called intermediaries liability for online copyright infringement. I would repeat, section 79 of the IT Act, 81 of the IT Act is to be read along with section 51 of the Copyright Act 1957 in order to understand the intermediaries liability for online copyright infringement. Well, my dear friends, let me tell you or take you to all these sections one by one. As far as section 79 is concerned, it in its very first subsection exempts the intermediary from any liability for providing any third party information, data or communication link through their platform to the users and subscribers of different websites. I am repeating it, my dear friends. This section is a non-obstante clause which reads, notwithstanding anything contained in any law for the time being in force, but subject to the provisions of subsection 2 and 3, an intermediary shall not be liable for the third party information. This is what this clause explicitly reads. Actually, it is a general exemption provided subject to subsection 2 and 3, of course, but under subsection 1, intermediaries have been exempted from any sort of liability for any third party information, transmission of any data or communication link made available by them. Just because they are intermediaries, they have been provided a safe harbor, and the premise behind providing this safe harbor or this immunity and exemption is to encourage free speech, to encourage free dissemination and distribution of the works of the people to the others. Well, my dear friends, if we go and read further this section 79, we get to see that the immunity provided here, the exemptions lying under section 79 subsection 1 are not absolute, because subsection 2 and 3 as written in the preceding clause or in subsection 1, they supersede this exemption, or you can say these are the limitations or some restrictions on that exemption or immunity provided under section 79 subsection 1. Let me take you to the restrictions and limitations of exemption or immunity. Subsection 2 of 79 reads, the provisions of subsection 1 shall apply if the function of the intermediaries is limited to providing access to a communication system over which information made available by third parties is transmitted or temporarily stored or hosted. This is what I was mentioning in the background before I started formally giving this lecture, that if something gets stored temporarily while hosting or while transmitting that information or that data, or while making that information available to third party or to anyone else, if it gets stored temporarily, then intermediary shall not be made liable, because it is explicitly written here that the function of the intermediary is limited to providing access. If the intermediary remains confined to this role of providing access to a communication system through which some information is being made available to third parties or is transmitted to third parties, which may temporarily get stored or hosted, then that intermediary, whose role is only of providing access, that intermediary shall never be made liable for any sort of infringement. Even if infringement has taken place, user or the subscriber, while accessing that third party information or any data made available by the third party, has copied that, had reproduced it, or has further communicated or issued it without the authorization of the owner of the copyright. But intermediary shall not be made liable, because his role has remained confined and restricted to providing access to a communication system. He has not gone beyond that. Subscriber, user, doing any of the impugned acts can be made liable squarely, because he has unauthorizedly reproduced, or he might have unauthorizedly transmitted, issued, communicated the work to the public, etc., etc. But if he is doing it temporarily, even that subscriber or a user cannot be made liable, because under section 52 of the Copyright Act, some exemptions are provided for transient or accidental storages of information, which happens to take place, or which usually takes place while saving any of the files or while accessing any of the files through the internet medium, which is actually automatic process. No human intervention lies in that process. If we go ahead and see the further things or further clauses of the 79, we see that intermediary shall not be made liable if intermediary does not initiate the transmission. Another reason of, or another factor on the basis of which an intermediary cannot be made liable is when the intermediary does not initiate the transmission, he should not be made liable. Suppose the transmission of the information or the data has been done by one party and is being made available to another parties at the another hand of the spectrum or another side of the spectrum through the middleman called intermediary here. If the intermediary had limited role of just providing that information through that information system, or if the intermediary had no role in initiating the transmission of that information which is going to the another side of the spectrum, then that intermediary shall not be made responsible or can never be held responsible for any online copyright infringement which may take place or which might have taken place in this case. Another factor on the basis of which intermediary can be exempted for any sort of liability is when the intermediary does not play any role in selecting the receiver of the transmission. If we look at section 79(b)(2), it reads that if the intermediary's role had remained confined as what? As a middleman or an intermediary for providing information or data being transmitted through him, but his role is limited as a facilitator only, and he had no role in initiating the transmission and in selecting the receiver of transmission. See, there are several people who actually provide the information and they just facilitate, intermediaries just facilitate in making these several informations provided by several people available to several users on the other side of the spectrum. So if the intermediaries had not played any role, had not played any function in selecting the receivers of the transmission as to who will be the receivers out of several receivers of this transmission, then their role had remained confined to what? To just a system providing the information to the people. They had not even initiated, they have not even played any role or key role in receiving the transmission. Also, another factor which is important to give them the immunity under this clause is that they had not even played any role in selecting or modifying the information contained in the transmission. If they have played any role in modifying the information or in selecting the information contained in the transmission, several people have provided the information, say a person A to Z has provided the information through the intermediary B to several people on the other side of the spectrum. When the intermediaries are not playing any role in selecting whose information will go to whom, as well as in selecting or modifying the transmission or information through the transmission contained in that transmission. If they have not picked up the information and modified it, if they have not selected the information and further transmitted it, then their role remains simply confined to one thing, that is being a facilitator of providing the information the way it came to them, was supplied further to the receivers of those transmissions. They had not selected, modified, they have not initiated, they have not even selected the receivers of the transmission. So in these following cases, my dear friends, intermediaries shall not be made liable at all for any sort of online copyright infringement. If you read further this section 79, especially its clause C, which reads that if the intermediaries have observed due diligence while discharging their duties under this act, and they have also observed such other guidelines as the central government may prescribe in this behalf. Actually, central government has prescribed under intermediaries rules of year 2003 some of the rules to be followed by all intermediaries. So if the intermediaries have observed due diligence, what does this due diligence mean? I'll come to that while taking up a case study, my dear friends. If the intermediary has observed a due diligence while discharging the duties under this act and has also observed the guidelines, intermediary rules actually of 2003, then in that case the intermediaries shall not be made liable in any case whatsoever, irrespective of the fact that somebody's copyright has been infringed by the user or by the subscriber or by the receivers of those informations or of the transmission. But intermediaries' role remained confined, that is why they cannot be made liable for copyright infringement which had taken place in this online medium or in this online platform. Well, my dear friends, if I move ahead and refer to subsection 3 of section 79, to which subsection 1 of section 79 is subjected to, it reads that provisions of subsection 1 shall not apply. It means in a way that intermediaries shall not be accorded with this exemption or immunity if the intermediaries has conspired or abetted or aided or induced, whether by threats or promise or otherwise, in the commission of any unlawful act. Well, my dear friends, let me just recapitulate as to what all we have read under section 79. If you look carefully, section 79 under subsection 1, it says that intermediaries shall not be made liable for any sort of copyright infringement that takes place online for doing what? For providing any information or any data to the receivers of those informations of a third party. But this exemption or immunity is subject to subsection 2 and 3 of 79. Right now on your screen, subsection 3 is there of section 79, and on the previous slides we have seen the contents of subsection 2, which reads that intermediaries shall not be made liable if they have not played a role of more than an intermediary, or you can say if they have not initiated the transmission, if they have not selected or chose the receivers of that transmission, if they have not selected and modified the content transmitted of third parties to the receivers of those informations or transmissions, or if they have applied the due diligence, or if they have observed, you see, all guidelines as the central government has prescribed in this regard or in this behalf, then they cannot be made liable. But subsection 3 of 79, my dear friends, says that intermediaries' exemption or immunity will not be accorded to the intermediaries if they have conspired or abetted or aided or induced, whether by threats or promise or otherwise, in the commission of unlawful act. It means if they were hand in gloves, or if they have instigated or aided or induced, if they have played a role where they had been instrumental in selecting, in modifying, in picking up the informations being transmitted of the third party to the receivers of those transmissions, then you see it can be said that they were aiding the receivers in committing the copyright infringement or in committing the online copyright infringement, and in these cases they can be held liable squarely for copyright infringement. Well, my dear friends, as far as section 79 is concerned, I believe that we have had the threadbare discussion on section 79, and that much is enough as far as section 79 is concerned. Moreover, if you look at the further clause under subsection 3 of section 79, which reads that if they have received the actual knowledge, and after receiving that actual knowledge, if they have, you see, taken down the impugned material from the website, then they cannot be held liable. We will see all these aspects one by one while taking up a case study, but I would like to take you to the another provision which is important to understand, the intermediaries liability, because I mentioned that there is a trilogy of sections to be referred to or to be seen in or to be taken into consideration while understanding the topic of intermediaries liability: section 79, 81 of the IT Act and section 51 of the Copyright Act 1957. Let me now take you to section 81 of the Information Technology Act, which reads that this act will have an overriding effect for its sweep or for its application on any of the laws available for the time being in force. Let me tell you as to why I am referring to section 81, my dear friends. There is a proviso under section 81 which says that this act, which has an overriding effect, will not have an overriding effect if there comes a matter of somebody exercising any of the rights conferred under the copyright law or on the patent law. The practical application or interpretation of the proviso of section 81 means that in the cases of online copyright infringement or in the cases of online patent infringement, IT Act will not apply. Rather, the proviso is giving a sense as if that the Copyright Act or the Patent Act, which are special statutes in that regard, they will remain applicable, and nothing contained in this act shall restrict any person from exercising those rights conferred under the Copyright Act, under the Patent Act. Practically speaking, my dear friends, the narrower interpretation as done by many courts in many judgments of this proviso was that IT Act will never get invoked in the cases of online copyright infringement, and exemptions provided to the intermediary by purview of section 79 will not be applicable, since IT Act is not applicable in these special cases by purview of the proviso according to that narrower interpretation. Then intermediary shall never remain exempted or immune. But my dear friends, let me tell you that this section 81 through its proviso never wanted to convey this interpretation, which is actually a narrower interpretation. Rather, 81, speaking through its proviso, comes up with a broader, protection to be made available to the owners of the copyright for exercising their rights conferred under the copyright and under the patent law, because these provisions are supplementary provisions to that of the Copyright Act or the provisions of the Patent Act. These provisions are not derogatory to the Patent Act or to the copyright law, and that is why this proviso says that those rights which are made available by purview of the special statutes, say a copyright law and the patent law, they will also get invoked and can also be exploited and exercised, as well as provisions under the IT Act will also be invoked and applied and can remain applicable. It nowhere says that these provisions will not remain applicable, because as per this section 81, IT Act has an overriding effect, but that does not mean that IT Act will alone apply in such cases, and provisions of the Copyright and Patent Act will become inapplicable or redundant. It has never been the purport of the legislature while evolving this proviso. Rather, their purport was to give a broader construction and broader and encompassing construction and protection to the peoples of copyright or to the people of patent, having patent or having copyright under the Patent Act and the Copyright Act respectively. Well, my dear friends, let me now take you back to what was written under 79. If you look at 79 carefully, it makes intermediaries not liable, or it immunes or exempts intermediaries from any sort of liability for any third party information or data or communication being made available through them or hosted by them. And when we read it in light of section 81's proviso, in our prima facie observation or in our prima facie interpretation, we think that this proviso actually ousts or excludes copyright law, or for that it excludes IT Act and its application on this aspect. And in this context, in our today's context, the meaning of this therefore would be that exemption provided under the IT Act will also not be available or will be inapplicable for the intermediaries. But my dear friends, it has never been the purport of proviso to section 81. Had it been the intention of the legislature, they would have incorporated a proviso like this under section 79 instead of including it in 81. Had they thought of ousting the applicability of exemption provided under 79 to the intermediaries, they would have included and incorporated a proviso like this of 81 under 79 instead of making a proviso under 81, because that would have made a more sense in a way, because 79 would have categorically said through a proviso or speaking through a proviso had there been such a proviso under 79 that in the cases of copyright infringement, online copyright infringement, the Copyright Act and the Patent Act will remain applicable and no exemption or immunity as provided under 79 will be applicable. But the legislature has not done so. Rather, legislation has chosen to keep a proviso under 81, which is supplementary to 79 as well as supplementary to copyright infringement provisions provided under Copyright Law of 1957, which is section 51. It is nowhere derogatory to that. So in a way you can say, to conclude this, that it has got a broader interpretation when it is read along with 79 harmoniously and along with 51 of the Copyright Act, and the broader contour and the construct of these three sections here is that intermediaries still enjoys that immunity and exemption as provided under the Information Technology Act through section 79 if they qualify whatever is written under subsection 2 and 3 of 79, and this section 81's proviso has no inhibiting implication on that exemption provided there, as well as the further interpretation goes like this, that 81's proviso is supplementary to 51 of the Copyright Act and is not derogatory to 51 of the Copyright Act, which means that this IT Act can be invoked as well as copyright can be invoked in the cases of online copyright infringement. Now, my dear friends, let us take a case study. Whatever we have discussed or whatever time we have devoted in understanding the broader interpretation or a broader construct of section 79, 81 and 51 of the Copyright Act, it will get patently manifested and it will get more threadbarely manifested when we take up this case study called Myspace versus Super Cassettes Industries Limited of Delhi High Court, decided in 2016. Well, my dear friends, let me tell you that this case is a division bench judgment, and it is a case where this division bench of Delhi High Court, comprising Justice Ravindra Bhatt and another lady lordship, this judgment has actually reversed this single judge's order of Delhi High Court in the matters between Super Cassettes and Myspace. Now here Myspace has come into an appeal to Delhi High Court in 2015 against a case filed by Super Cassettes Industries Limited in 2007 against Myspace. So you see, if you go to the historical fact sheet, the matter actually heralded in year 2007 when you see Myspace was alleged to have found or was alleged to have done online copyright infringement of the copyrighted material of Super Cassettes Industries. Super Cassette Industries, my dear friend, is popularly known as T-Series, or also owns T-Series basically. Super Cassettes Industries Limited has a huge repository of musical work, sound recordings, cinefilms, etc. T-Series own lakhs of songs and they have a valid copyright on those songs. They alleged in 2007 that Myspace, which is a US based server and acting like an intermediary, has been found by Super Cassettes here infringing the copyright material, which is cinefilms and songs owned by Super Cassettes or T-Series here in an online platform, because Myspace provided a platform called myspace.com where it allowed the users to upload, to stream or to download musical works, cinefilms, etc. But they never owned a copyright on that musical work or on cinefilms. The copyright was of the owners on that work. In this case, you see, Super Cassettes allege that they own several songs which have been made available through the platform of Myspace to the subscribers and users of the Myspace, from whom Myspace is charging some subscription fee, and they have been allowed to download, to stream, to upload any musical work or a cine work sitting anywhere in the world without any involvement of the Myspace, though as taken in defense by the Myspace that they had no role to play as far as selection and modification of the content is concerned, and they had not even seen what is being uploaded, what is being downloaded and is being streamed by the users or by the subscribers of this work. Moreover, my friends, you see, if you look carefully the fact sheet, Super Cassettes Industries Limited in this case also provided with the knowledge to the Myspace about this infringement being done or is taking place on the portal of the Myspace. But the point to be taken note of, and the point which is noticeable here, is that Super Cassettes failed in providing the actual knowledge of the content which was being infringed online. They just provided a general information to the Myspace people, and that general information contained lakhs of songs which are owned by Super Cassettes Industries. They did not provide specifically the information of the works which was being infringed. Well, this is all about the fact sheet. I'll come to the legal aspects of this case in my later discussions with you or in my later lectures in the next week. Thank you so much. Have a very good day, friends. Thank you.
With this note, thank you, sir. Thank you so much for giving us this in-depth knowledge. And friends, as said by Dr. Ashwini Sewal, that we are going to continue further in our forthcoming sessions. So you are required to be connected to us as always you do. Friends, if you have any question and if you have any query or feedback for this lecture, do write to us at info.cec@nic.in. We are taking your leave with the promise that we are going to meet soon. Till then, take care. Goodbye. Thank you, sir. Thank you once again.
Thank you. Welcome.